Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we interview guest speakers but also the experts of our global alliance from all over the world, and we discuss about trending or latest news related to technologies, privacy, data protection, but also cybersecurity, everything that deal with the world of technologies. Today we are with Stephan Mulders from the law firm Diepen Van der Kroef, based in the Netherlands. They are members of the Privacy Rules Alliance, and Stephan is our main contact point and expert that you can connect with whenever you have a need in the Netherlands, but also in his field of expertise, including the one that we are going to discuss today with him, because there is some interesting news from the Netherlands related to data protection, of course, case that was regarding Uber, pretty famous company, I would say. So yeah, Stephan, first of all, thanks a lot for being with us today. Can you just start by telling us a bit more on what happened in this case?
Yeah, well, Alessandro, thank you very much for having me here. Just in December last year, the Dutch DPA imposed a fine of 10 million euros on the car sharing company Uber. And this fine, the whole legal privacy world in the Netherlands was kind of shocked, because the DPA found some infringement, but these violations of the GDPR mainly saw on two things, basically on a violation of the transparency obligations, and also on not complying to access the data subject access request. And the point is, what's the most shocking is, first of all, the amount. It's the highest fine that was ever imposed by the Dutch Data Protection Authority. A few years ago, the second highest fine was 3 million, and now it's 10 million. So that's like a lot. But also because the violations are, well, to say the least, a bit arbitrarily. I mean, for instance, one violation was that the DPA said, well, you didn't provide an easy enough way to request for access by the data subject. So to file an access request, what the DPA said, well, the user had to take 6 steps, and that's too much in the app. And also, what you did is you provided the information in a comma-separated value format, CSV, and that's also not a convenient format. And also, because you didn't, Uber is a company which provides service over whole Europe, and you only provided information in English, and that's, well, not always understandable by people in other European countries. So they said, well, you didn't provide clear enough information. And you mean the second part was that the privacy statement of Uber wasn't clear enough. There was not clear enough information on retention periods and things like that. But the point is that to most people, these things, well, they're obvious. They can be viewed as violations. That's one thing. Whether you need 4 or 6 or 3 steps to reach an access form, that's something, well, you can debate about this. It's not a clear norm. There's also no one says, well, you cannot provide information in CSV files. That's just it's not a clear norm. But no one would say, well, these are very serious infringements. I mean, if this is the worst, if this is your biggest problem in privacy compliance, well, then you are doing a pretty good job. And also, Uber just fixed everything after that. So still, they are slapped with a fine of 10 million, and that was quite a shock here.
Yeah, that's very interesting. From the one side, listening to you, and thanks a lot for that. I was noticing that, yeah, I mean, the fine was very high all of a sudden, so that's impressive. So it's clear on my side that this might have been, the case for the authority to, give an indication to other companies, in particular big tech, as Uber can be considered one of them, in being compliant and being very attentive to what they do and how they do it. But on the other side, of course, this has also some issues that are related to the approach, as you were rightly saying. In this regard, do you believe that such a fine will be held up in court or not?
Well, the problem is that the Dutch Data Protection Authority, they don't have a really good record on this part. I mean, just last month, one of their fines was voided by the court. There was a fine concerning Wi-Fi tracking by a Dutch municipality. And there, the court found that the municipality didn't process personal data. The data was not related to identifiable persons. So that was quite a thing. Another fine was annulled a few years ago, in which case the Data Protection Authority said, well, economic interest cannot be a legitimate interest in the sense of Article 6.1 under F, and that's quite a controversial standpoint. And also in that case, the court annulled the fine. However, the company who was fined already went bankrupt. So that was kind of it was not a really nice story. So the point is that the Dutch DPA doesn't have a real strong record on defending fines in court. Another thing is that you can rightly ask, well, is it proportional here to actually fine a company for these kind of violations? I mean, the norms that the DPA set are somewhat arbitrarily. You could argue about them, and I believe that Uber also could argue, well, we did provide the information according to our best knowledge. Also, Uber just changed their policies immediately after the DPA investigated this case. They said, well, then we will change it, and we will make amends. We will improve our policies. So you could ask, well, is this completely proportional here to actually give a fine and not just give a warning or give instructions to improve it? But what you see here is that the DPA applied EDPD guidelines on the calculation of fines. And what you see there, they obviously motivate the amount of the fine, but they said, Uber is a large company, which means that the maximum fine could be like 2 billion euros, and we are only asking 0.49%, because we also see that it's a slight violation. But still, 0.49% of a lot is still 10 million here. So what you see is that these guidelines, if you apply them for large companies, can still lead to very big fines for really small violations. So that's probably the reason why such high amount was charged here.
Yeah, it's a very good point, and this open up also a big discussion, also maybe under more ethical perspective, meaning how does it work? Is it a right approach? Someone may say, if you don't use these fines, those big tech would never take care even of smaller duties. I mean, it's a big discussion, but it's difficult to strike a balance. Is for sure a point. Also listening to many of your colleagues in the past, the one of lack of guidelines before fining, or having an approach where you before give some advice and then you fine. This is something that I think can be easily discussed, meaning that is something that normally is appreciated by companies, because of course it's still a sector that is evolving daily, so it's not always that easy to be compliant with regulation that are changing this fast, as it's happening in the EU, for example. So I understand that come closer one to the other may help both companies and authorities sometimes in this regard.
Yeah, what the point here is that also when drafting such privacy policies, you always have to make like a decision. Are you going to provide more information? It will get longer, and then it might be too complicated. So that's also, it's always a bit of a judgment that you make. And what the DPA is saying here, well, Uber, you made the wrong judgment. But still, Uber's stance is not completely unreasonable. They thought about it to make a certain decision. So it's very hard to actually, as a company, say, well, I, as a data controller, to prevent such fines. If the authority just says, well, you have a reasonable opinion, but I have another, so I will give you a fine, that's very hard to act on, especially if you, as Uber did, just change the policy as soon as the privacy authority says, well, change it. So they cooperate fully.
Yeah, that's right, absolutely. And those are, I think, all points that will be considered probably in court as well. And I think that another key point of what you're saying, we have been focusing a lot on Uber, but it's clear that those type of fines or cases becomes the case that then leads the way to future ones in a positive and negative manner. So which do you think are the consequences of such a case, in particular for other organizations?
Well, it shows kind of a parity, like a shift in the behavior of the DPA. Well, before they mostly acted on cases where they were fairly sure. Like the first fine was because a Dutch company, Booking.com, didn't notify of a data breach. And this was perfectly clear from all the correspondence that the board just said, well, just wait with the notification. Well, clear-cut case. This is easy. It's a clear violation of the GDPR. But so there's a different here is that now the DPA is saying, well, even on the smaller issues, we are going to act and we are going to enforce the GDPR. So I believe that companies should really review their privacy statements and look them over carefully. Pay attention to retention periods, look over your data subject request policies and try to improve them, because if the data protection authority actually comes at your door, you're too late. That's one thing. The second thing is that, well, this cannot really be prevented. You just have to be really careful in drafting all these policies.
Yeah, indeed, and I think it's there is always a little part of risk whenever you deal with those type of sectors. In particular, nothing can be under full control, 100% under full control. Of course, we learned this a lot with cybersecurity. Every cybersecurity company always says, we can protect your company, but it's not 100% sure that you won't be breached. So that's part of the game. But I think that if you, as you were rightly saying, if the company that shows that there was the effort in protecting the information and also in responding and activating the company immediately after the request of the authority or a data subject, I mean, these are also things that counts a lot. I mean, having plan in mind, be prepared as much as possible, and also be ready to react whenever there is a need or a situation of difficulty. Those are important things as well that I think can be done only if you have someone like you are that is really an expert in the sector that can, more or less make some forecast on what can happen, prevent that, and give you the right indication on how to prepare also to what you've never experienced before, because that's one of the big issues in this sector. Stephan, I would like to thank you very much for your time with us today. We are running up of our time. So I also want to thank all our listeners for following this Privacy Espresso episode. Thanks a lot, and looking forward to meet you and all our listeners very soon again.
Thank you very much.